You're listening to the Valley Labor Report with David Story and Jacob Morrison.
Welcome back to the Valley Labor Report.
Yeah, welcome back, everybody. Appreciate you listening. If you want to call and chat with us, give us a call, 1-866-494-9866. That's 1-866-494-WVNN. This is the Valley Labor Report here with your hosts, Jacob Morrison and David Story. And I wanted to talk about these Supreme Court decisions, kind of walk you through what the lay of the land was before the Supreme Court made these decisions and what they did, and use that as another jumping off point to say what we say every week, like don't count on the government. You got to organize for yourself, and don't count on the government to help you, because they will throw you under the bus as soon as they can. So the first case is the one about the birth control and not having to and employers not having to put birth control in their health insurance. And so just to remind everybody, one of the things that the ACA did, the Affordable Care Act, was create a framework, a definition for what health insurance is. Like aside from health, like you're not supposed to false advertise. There are certain requirements that vehicles, for example, have to meet before they can be sold as road-ready vehicles. You wouldn't want to be sold a car under the impression that you can drive it off the lot and pay $10,000 for it and it not have an engine or transmission or something like that, right? Like there are certain things that a car has to have before it's a car. And so similarly with health insurance, the ACA had this bundle of things that had to be included before something could be actually called health insurance. Before that, they had these terrible bare bones catastrophe plans that almost never would help you unless there was like a catastrophe and they would call it insurance. So the ACA mandated certain things be covered under any insurance plan, and included in that definition is birth control. Why? Well, contraceptives as such are good. They prevent abortions, which is something that the evangelical folks are, supposedly they care about. They decrease teen pregnancies. They promote welfare for women. Just generally speaking, birth control is a good thing. It has a very positive effect on society. But aside from as a birth control measure, as a contraceptive measure, birth control pills are like genuinely healthcare. I mean, contraception is healthcare, but like there are physical problems that the birth control pill can help. And everybody in the audience knows that, like if you are a woman or women, like this is a common thing that so this is an important piece of healthcare. And but also it was known that some religious organizations opposed birth control. There's some churches that oppose it on principle, and the Obama administration had already made exceptions for churches and affiliated organizations to opt out of contraceptive coverage. There were no churches before this ruling that were made to get birth control for their employees. No, like church affiliates. Like that wasn't a thing that happened. What has happened now as a result of this latest Supreme Court ruling is that and additionally, 2014, I think it was, that the Hobby Lobby case decided that private, closely held corporations like Hobby Lobby that have like religious orientations don't have to provide birth control either.
Right.
And so there's all these exceptions already baked into the cake, like that if you're like a religious organization or a church, you don't have to provide birth control. What this did is now any large publicly traded corporation whose executives have strong moral convictions, quote unquote, the ruling doesn't even have to say it has to be religious, can opt out of the coverage as well.
And, here's something that needs to be said and you continue to use the term, this is not about birth control for a lot of people.
Right.
This is not about contraception for a lot of people.
As such, right.
I've got two daughters that both needed the hormones that's inside that's in these so-called, we need to get away from calling it birth control. We need to get away from calling it contraceptives. I've got two daughters that needed this medication to help alleviate their menstrual problems as teenagers. This is catastrophic.
It's healthcare.
Exactly.
There's no other way to honestly talk about this subject. It's healthcare. And so the end result is many women are going to lose employer-sponsored health care. The boss will save money, and that's what this is all about. And workers are screwed yet again.
Yep.
Okay?
Yep.
I'm going to talk about the second Supreme Court case, and we're going to talk about, like, what we reckon you ought to do about it. But the second one was, I'm just going to lay out the groundwork pre-court case again here. So here in America, the great United States of America, folks in power, they don't believe that workers are entitled to much of anything from the boss, right? They reckon the boss ought to be able to offer whatever exploitative, horrible contract that they can get a worker to take. However, there are just a few worker protections that have been enshrined into law, making employment contracts that violate those norms illegal. Among those protections are those that are codified in the Civil Rights Act. Because of that act, employers are unable to fire or not hire somebody because of race, color, religion, sex, or national origin. And a later act protected people over the age of 40 from age discrimination. Okay? Much like the birth control ruling, there has always been exceptions to this rule. And this is a reasonable exception, I think. And that exception is the ministerial exception. And what it has always said is basically churches and religious organizations have never had to adhere to the Civil Rights Act when hiring ministers. And that's reasonable, right? You're not going to hire a Christian to be an imam at a local mosque, right? So that's a reasonable exception. I think everybody agrees to that. I don't think there's ever been a case that a Christian was mad they didn't get hired as an imam at a local mosque, or a Muslim was mad that they didn't get hired as a Christian minister at the local Baptist church like that. And so this is long.
It's all dog whistles.
Yeah,
all this is doing is throwing some raw meat to the base of the far right. It's just to say, look what we won from you. Guess what? You already had it.
Yeah, you already
had it.
What this ruling did was expand that ministerial exception beyond recognition, beyond reasonableness. I mean, it's just absurd. The ruling pertained to two teachers whose contracts were not renewed. One whose contract was not renewed after requesting time off because she had breast cancer, she was 60 after her 65th birthday, and this is supposedly a religious institution that cares about people. I mean, I don't know. A boss is a boss, folks. They're not your friend. But the Supreme Court stated that even though the overwhelming majority of these Catholic school teachers, they were Catholic school teachers, their instruction time, the overwhelming majority was spent teaching secular subjects, because they spent what amounted to less than 3 hours per week on religious subjects like church history or theology. They were ministers and thus exempt from civil rights law. Just think about that.
Think about that.
What this ruling opens the door to is if a religious organization has you on as a janitor or something, they can include in the job description, you need to lead a prayer once a week, and boom, you're a minister and you do not get the protection of civil rights law, which is just the bare minimum that workers have been afforded in this country. Just the bare
so much
bones.
For constitutionalism, so much for we the people.
Just reading the text of there's so much for just reading the text of the law. I mean, this is, conservatives, they pretend to claim to care about judicial activism, but this is just inserting ministerial exceptions, judicial activism for religious freedom, quote unquote, that's not in the law. It's not in the law. This is the Valley Labor Report. We're going to talk more about this on the other side. If you want to talk to us, 1-866-494-WVNN. Stay tuned. Good morning, folks. This is the Valley Labor Report. My name is Jacob Morrison, here with my co-host, David Story. And when we left off, we were talking about these Supreme Court rulings, and so I just want to pick back up on that. If you want to call in, talk to us, the number is 1-866-494-9866. So this ministerial exception, I mean, what it did was it allows basically any church or quote-unquote religious organization to define just incredibly broadly who is a minister. And that is, it's just bonkers. Like these teachers, they taught secular subjects, and they did 3 hours per week of religious teaching. And like they were not made at the beginning of their, like they were not made to sign an oath that they were a Catholic or anything like that. Like this is not, they're not ministers. And so what this, like I said, what this opens up the ability for religious organizations or Catholic schools, which employ a lot of folks, is they can like add to the position of a secretary, like pray with people when they call, and boom, you're a minister. And now I, as the boss, I don't have to conform to civil rights law. It's insane. And then to make matters worse, on top of this, just to add insult to injury, another ruling this week stated that religious schools can take advantage of taxpayer subsidies and scholarships and grants, which when you bundle all this up together means that we, the taxpayer, are going to be funding institutions which are not accountable to civil rights law at all. Like, that's bonkers. That is lunacy. I mean, I don't know that I have any particular problem with religious schools getting taxpayer subsidies in and of themselves, but just combined with this, the fact that now they don't know, almost none of their employees, potentially none of their employees at all, are going to have the civil rights protections.
Yeah.
That's
the fact that
crazy.
They don't have to follow law.
Yeah.
I mean, law that's been set in place for years.
Man.
The fact that they don't have to follow law, they don't have to pay taxes. Now, I get it.
And now
all
they're
of their
getting taxes.
All of their folks that go to those schools or go to those churches, they pay property tax. I get it.
Yeah.
Kind of like you said, I see the need to help some of those folks out, but it's such two-faced to say, okay, you don't have to follow the federal laws of this country like many other companies do, but we're also going to give you the benefits of being an employer in this country. I mean,
and now, you don't have to pay taxes, and you don't have to follow the law, and we're going to just give you a bunch of money. I mean, on top of the tax breaks that you get as a church and religious. I mean, man, oh man, this is just, it's lunacy. And I do want to say real quick, somebody commented that the Little Sisters of the Poor, that they did have to provide birth control. WVNN. And like that's not true. They didn't have to provide birth control. What they did was they had to say that they did not want to. They did not want to provide birth control, and then the health insurance would have they could go to the person directly and offer that contraceptive coverage. And so what the Little Sisters of the Poor, what their issue was, that they had to signal in any way that they didn't want to have to that they didn't want to give contraceptive coverage to their employees, because in a roundabout way they thought they would be contributing to their employees getting contraceptive coverage. I mean, it's just like malicious. It's just malicious. They were not asked to pay for birth control or for contraceptive health care out of their own pocket, but they didn't want them to be complicit in any way in making sure their employees get health care. It's lunacy. Absolute lunacy. Thanks for tuning in, folks. We appreciate your time today. If you want to see what we're up to throughout the week, get our snide quips about the news of the day, then you should follow us on social media. We're on Facebook at facebook.com/Valley Labor Report. We're on Twitter at Labor Reporters. I'm on Twitter at JacobM_AL. David is on Twitter at Radical Unionist. That's spelled RADICL Unionist. If you missed part of the show and want to go back and watch it later, you can search YouTube for The Valley Labor Report and subscribe to our channel. You can go back and watch the full show there, and we also clip segments throughout the week. And if you appreciate our work and want to help keep us on the air, consider throwing us a couple dollars a month on patreon.com/The Valley Labor Report.